with bad intentions. They're all criminal contempt. The power of the Supreme Court and the High Court to punish the contempt is derived only from the Contempt of Court Act of 1957. That is not correct. You say Statement 3 is being contradictory to the Statement 1. In the Statement 1, the power of contempt of the Supreme Court and the High Court of India is derived from the constitutional powers under Article 129 and Article 215 of the Constitution. And contempt of court, power to penalize, contempt of the power to penalize under the contempt of court is one among the elements of basic structure of the Constitution. With the reference to freedom of speech and contempt of jurisdiction of the courts in India, consider the following statement. Statement 1, fair and the reasonable criticism of the judicial decisions. Fair and reasonable commentaries on the fair criticism of the decisions is protected under the freedom of peace and speech and expressions, provided it does not amount to the contempt of court. Statement correct. Court have consistently held that contempt power should be exercised with restraints and only when there is a serious interference with the administration of the court. Correct. The freedom of speech under Article 19, Clause 1, Subclause A, right to speech and expression, is not an absolute right. It is the right subjected to the reasonable restrictions. So Statement 1 and 2 are correct. Answer is A. In the context of the constitutional law, the doctrine of eclipse, A, the temporary shadowing of the constitutional laws that are inconsistent with the fundamental rights, making them inoperative in the extent of inconsistency. Correct. Statement of A is correct. Doctrine of eclipse. The court applies this doctrine at the time of judicial review of any legislation. At the time of judicial review of any legislation of parliament or the state legislature, court applies the two doctrines. One is the doctrine of eclipse and the doctrine of severability. Doctrine of eclipse, which means ஒளிமறைவு கொள்கை, முரண்பாட்டு கொள்கை, ஒளிமறைவு கொள்கை, doctrine of eclipse. A law is considered as invalid. A law is considered as ultra vires until any provisions that exist in the Part 3 is contradictory to it, called as doctrine of eclipse. Doctrine of eclipse. Any law passed by the parliament or the state legislature is considered as inconsistent to any provisions under the Part 3 of the Constitution. Is not amounted to dead. If that inconsistent provision is removed from Part 3, the law would become automatically in life. You take Land Appropriation Act. Land Appropriation Act of a pre-constitution. That means empowers the state to appropriate any lands for the defense purpose, for the public purpose. That is the Land Appropriation Act. அரசானது நிலத்தை கையகப்படுத்துதல் அரசினுடைய உரிமை. That was of the pre-constitutional. That was of colonial times. When Part 3 provisions came along with the Constitution, one of the provision in the Part 3 as Article 19, Clause 1, Subclause F, that deals with right to property. Right to property as a fundamental right for the individual. So, state right to appropriate the land come in inconsistent, contradictory to the Article 19, Clause 1, Subclause F. So, it is invalid. that invalid law is not amounted to debt. When 44th Amendment removed Article 19, Clause 1, Subclause F from the fundamental rights, the law became operative again. That is called as doctrine of eclipse. Purila? Doctrine of Purila. Purila. That is doctrine of eclipse. பகுதி மூன்றில் ஒரு சட்டம் தடையா இருக்கும் வரை அது செல்லுபடியாகாது. அந்த தடை எடுக்கப்பட்டால் 44வது சட்ட திருத்தம் அந்த தடையை விலக்கினார். உடனடியாக அரசுக்கு நில கையகப்படுத்தக்கூடிய உரிமை மீண்டும் உயிர்த்தெழுந்தது. That is doctrine of eclipse. Then doctrine of severability. முரண்பாட்டு தத்துவம். If a particular law, some provisions are contradictory to the part 3, but not other provisions. Some provisions are the contradictory. For example, A.K. Gopal, the communist leader, was arrested by the state of Madras in 1951. It was challenged in the court that he was arrested under Defense of India Act. It was challenged in the court that the provisions of the Defense of India Act is against the Part 3 provisions. So arrest is invalid. Arrest is invalid. But the court interpreted some provisions were invalid, but not the other provisions. So Gopalan to be arrested. To be arrested. If a particular law, certain provisions are inconsistent to the part 3, but not the other provisions, court would apply the doctrine of severability by separating the inconsistent provisions and declare that inconsistent part as invalid, but not the other part. Some provisions of the Defense of India Act may be invalid, may be inconsistent, but not the other part. If a particular law, it is impossible to remove the contradictory provision from the incontradictory provision, means ஒரு சட்டம் அடிப்படை உரிமைகளை சட்டத்தின் சில பகுதிகள் அடிப்படை உரிமைகள் எதிராக இருந்தால் நீதிமன்றம் அந்த முரணான பகுதிகளை மற்றும் செல்லுபடியாக்காது. அதாவது நீதிமன்றமானது முரண் பகுதிகள், முரணில்லா பகுதிகள் என்று இரண்டாக பிரித்து செயல்படும். ஆனால் ஒரு சட்டம் முரண் மற்றும் முரணில்லா பகுதிகள் என்று பிரிக்க முடியாமல் போனால் the entire law is invalid. That is doctrine of severability. Doctrine of eclipse, doctrine of severability is applied at the time of judicial review in the Constitution. Question 5. With reference to the constitutional status of Vande Mataram, Vande Mataram don't have the constitutional status. And the other national symbols, consider the following statement. Constitution of India explicitly mentioned national anthem and the national song in its text. No. Constitution of India nowhere mentions national anthem. If the Constitution of India mentioned the Jana Gana Mana, it would be sent to dustbin already. Okay, no, Jana Gana Mana is national anthem of India. Vande Mataram is a national song of India. Okay, correct. Article 51A make it a fundamental duty in respect to the national flag and the national anthem. Correct. Any refusal to sing the fundamental duty. Okay, correct. Any refusal to sing the national anthem and automatically amount to the contra. No, fourth is not correct and one is not correct. Answer is 2 and 3A. With reference to the citizenship and the domicile in India, any second opinion? Okay. With reference to the citizenship and the domicile in India, consider the following statement. Citizenship means citizenship and the domicile. Kudimagan மற்றும் வளர்ப்பு மகன். Okay. குடிமகன் குடிகார மகன். Okay. Say a constitutional framework is based on the principle of single citizenship. A citizenship is a constitutional conferred status. Who is a citizen? A citizen is a member who is the fullest member of the political community of a nation. That is the citizen. Okay. Domicile means an individual who is having the permanent residence in a particular part. That is domicile. That is the domicile. I'm an Indian by citizenship, but in domicile, my domicile is Tamil Nadu. Okay, my domicile is Chennai. Constitution, so first statement, constitutional framework. Indian constitutional framework is based on the principle of single citizenship, correct? Constitution distinguishes the citizenship from the domicile and permit the states to prescribe the domicile based on the conditions of certain rights and benefits, correct? For the TNPSC, certain positions you need the domicile of the Tamil Nadu. For the need to have that 8% reservations, you need domicile of Tamil Nadu. Constitution permits. Both the statements are correct. Answer C. With reference to the Sons of Soil, Siman, Sons of Soil policy in India, consider the following statement. Consider the following. Manin Maindan. Okay. Sons of Soil. Such policies may create a differential treatment between the local residents and the migrants, raising concern against the constitutional principles of equality. Correct. It's a concern on the constitution because the issues will be raised. Vadakan, Thirkan, the issues. Such policies are constitutionally permissible in the public employment only. Constitutionally permissible in the public employment only, and limited circumstances such as when the parliament makes a law prescribing residence as conditions under Article 16, Clause 3. Article 16, Clause 3, which states the state shall not discriminate any individual in case of public employment only on the grounds of race, religion, sex, place of race, religion, sex. So it is Article 16, Clause 3 gives permits the place of birth permits in public employments as a part of protective discriminations. That is, both are correct. Answer C. With reference to the powers of the Lieutenant Governor of the Capital Territory of Delhi. Lieutenant Governor of the Capital Territory of Delhi. Which of the following statement is not correct? Not correct. Questions. First negative marks. So we have to approach the question first. In every discussion, we will be having two lessons. First lesson is our attitude is to avoid the negative marks. To avoid the negative marks, first read the question. Read the question. Correct or incorrect? Read the question. Read the first lesson is reading the top statement of the question. Okay, first lesson of the preliminary MCQ aptitudes. The Lieutenant Governor has the control over public order, police, land in Capital Territory of National Capital Territory. Correct. Lieutenant Governor may reserve certain bills passed by the Legislative Assembly for the consideration of the President. Correct. Lieutenant Governor can act independently on the elected government in the matters where the discretion is constitutionally provided. In certain matters that is conferred with the discretionary powers where he can act independently. Lieutenant Governor has the power to appoint or dismiss the Chief Minister. Chief Minister is appointed as per the confidence enjoyed in it is not his discretionary power. It is not his discretion. At the time of Anga Assembly, it is his discretion, but not its answer is D. D is not correct. With reference to the Prevention of Money Laundering Act, 2020-02, which of the following statement is not correct? Enforcement Directorate, ED, is the primary agency responsible for enforcing the provisions of the Prevention of Money Laundering Act. Correct. Act deals with the offense of money laundering and attachment and confiscation on the proceeds of the crime. Act deals with the offense of money laundering and attachment and confiscation of the proceeds of the crime. PMLA is exclusively addresses the offense relating to the terrorist finance and does not cover the other economic crimes. Not correct. PMLA, the offense of money laundering is directly linked to the existence of schedule of funds, which generates the proceeds of the crime. Correct. See, offense are the two types. PMLA distinguishes the offense of two types. The schedule offense, that means those offense that was listed in the schedule of the act. Then the proceeds of a predicated offense, that means the offense as the proceeds of particular, the proceeds of the particular, particular one. PMLA not exclusively deals with offenses relating to the terrorist finance, but also the other offense of the economic crimes, as the when it comes under the scheduled offenses. When it comes under the scheduled offense, that is the C is the answer. With reference to the mob lynching, the legal framework, mob lynching and the legal framework of India, consider the following statement. Bharatiya Naya Sanhita, Naya Sankita, Bharatiya Naya Sankita 2023 explicitly recognizes the murder committed by a group of 5 or more persons on the grounds such as race, caste, community, sex, language, and personal belief as a distinct offense. Correct. The National Crime Record Bureau publishes a separate dedicated annual data set exclusively on the incidents of the bomb lynching. No separate National Crime Record Bureau not giving a separate list of offenses on the mob lynching. In the absence of the specific central anti-lynching law, incident of the mob lynching can be prosecuted under the general criminal law provisions relating to the unlawful assembly, rioting, conspiracy. That's correct. There is no separate law of the mob lynching in India. So the second statement is not correct, and only two statements are correct. B. Question number 11. Consider the following statement. As regard the National Commission for the Scheduled Tribes, it is empowered to investigate and monitor the implementation of the constitutional safeguards provided for the scheduled tribes. Correct. Statement 2. Commission can inquire into the specific complaints relating to the deprivation of the rights and safeguards of the scheduled tribes. Correct. Commission can issue legally binding orders to the state governments, for the mandatory implementation of the welfare schemes, legally binding orders of the state governments for the mandatory legally binding orders. Commission cannot give the legally binding orders to the state governments. Commission cannot give the legally binding orders of the state governments. Statement 1 is correct. Statement 2 is correct. And statement 1 and 2 substantiate each other. Statement 3 is not correct. Okay. Provisions are the problem. Okay. We'll look into that. With reference to the C. Okay. With reference to the power of the Human Rights Commission under the protection of the Human Rights Act of 1993, consider the following statements. NHRC can conduct inquiries into the alleged violation of the human rights and can also take the sumoto cognizance of any matters. Correct. NHRC can issue arrest warrants. No. NHRC is not a criminal court. Cannot issue the arrest warrants. NHRC can recommend the prosecution and compensation, but recommendations are not legally binding. Correct. NHRC can impose fines and criminal. Not correct. 2 and 4 not correct. 1 and 3 are correct. A. Consider the following statements. Under the Indian law, electronic publications are the transmission of absence materials. Absence materials is regulated by the Information Technology Act of 2020. The indecent statement 2, correct. The indecent representation of the women's prohibition of indecent representation of Women's Act of 1986 permits unrestricted artistic. It not permits unrestricted artistic depiction. That is not correct. But the statement 1 is correct. Statement 2 is not correct. Answer is C. With reference to the domicile-based reservations in education, consider the following statement. Supreme Court has recognized that the Indian Constitution envisages only a single domicile. It is not That is the domicile of India. That is citizenship. Supreme Court never talked about it. It is amounted to a single domicile. Correct. Any form of institutional or domicile-based preference in admission have been held uncorrect. That is not correct. That is not. The answer is 1A. With reference to the reforms, 15. With reference to the reforms in the medical education in India, consider the following statement. NEET was introduced to promote the uniform and merit-based standards in the medical admission. Correct, but don't like by, but not correct to DMK. The condition, the Constitution mandates permanent regional quotas. Constitution mandates, no, Constitution don't mandate permanent regional quotas. The National Medical Commission of 2019 replaced the Medical Council of India. 1 and 3 are first statement are correct. First statement are correct. Secondary statement is wrong. Second statement is wrong, and the third statement is correct. So answer is, with reference to the linguistic organization of the states in India, consider the following statement. With reference to the linguistic organization of the states in India, consider the following statement. State Reorganization Commission accepted language as an important factor in reorganization of the state boundaries. Correct. Linguistic reorganization of the states in India significantly intensified secessionist movement and weakened the national unity. That is not correct. It is not the linguistic reorganization of the state. What are the merits of the linguistic reorganization of the states? Linguistic reorganization of the state has provided a psychological or the emotional security for the people. Then administrative feasibility. Then it promoted national integrations in harmonious terms. It is not, it intensified secessionist movement. So one is correct. Second is not correct. With reference to the Indian national flag, consider the following statement. Flag Code of India 2002 was amended in 2021 for a liberal use of the flags. Correct. The Ashok Chakra in the center of the national flag represents Dharma Chakra. Correct. The Constitution of India explicitly describes, not Constitution of India, not talks about the national. 1 and 2 are correct. Match the following. Preamble. So match the following. Preamble can be used in the aid and interpretation, but not as a source of power. Preamble is a part of Constitution, and its ideal guides the limits of the amending power. Then inserted the words socialist, secular, and integrity. 42nd Amendment. Lay down the limits of the misuse of the particle. Keshwan, the SR Bommai case, as the judicial restrictions on the misuse of Article 356. Then preamble is the can be used aid and interpret, but not the source of power. The Berbari case. And preamble is a part of Constitution, and it can guide at the time of ambiguities, and the Keshwan and the Bharati case. So answer is A2, B3, and D1. Okay. Okay. Answer is A. With reference to the Magna Carta of 13th century of King John, certain provisions of Magna Carta laid the foundation of modern principle of due process of law. Modern principle of the due process of law. Correct. The due process of law, which means due process of law. Okay, very good. Due process. I say Article 21 deals with the procedure established by the law. The procedure established by law. State shall not violate state shall not deprive the right to life and personal liberty without the procedure established by law. Up to 1982, court established the doctrine of procedure established by law. The procedure established by law is one the court can go through executive actions. If a particular person detained without following the procedure, you see section 144. Section 144 is promulgated in a place means it should have certain procedure. It should be promulgated only by the Commissioner of Police or the District Magistrate. Section 144 need at least 4 persons. 4%. That means Section 144 considered that it is a criminal offense of gathering in a public place when the law is promulgated. I need 4 persons. If the police arrested 3 persons under Section 144 means wrong procedure. Wrong procedure. Police has to take care of that Digebasu guidelines for the arrest. If violated means wrong procedure. So invalid. Up to 1982, court applied the article application of Article 21 under the doctrine of procedure established by law. Procedure established by law was the UK Convention. But in 1982, the Manaka Gandhi case. In Manaka Gandhi case, court stated right to life, though Article 21 not mentions the due process, but the right to life and personal liberty can be ensured only with the due process. Doctrine of due process of law. Doctrine of due process of law, which enables the right of the court to verify not only the procedures carried by the executive action, but also the procedures laid down by the legislature. The procedure should be a fair procedure. A procedure should have principle of natural rights, principle of that is the due process of law. Magna Carta is having the due process of law. Right guaranteed under the Magna Carta is intended to apply equally to peasants, serfs, not equally to everyone. Especially everyone. It is a question deals with the taxation. 2 is not correct. So answer is A. Consider the following statement. Right to privacy is an intrinsic part of the right to life and the personal liberty under Article 21 of the Constitution. Correct. That was applied in the Puntaswamy case by the Supreme Court. Recognized the privacy as a fundamental right. Both the statements are right. Both are substantiating each other. Election Commission of India, Finance Commission, UPSC, Controller and Auditor General. What's the answer? A is the answer. 22. Article 32, Article 20, Article 280, Article 356. Answer is yes. With reference to Article 14, consider the following statement. Statement 1. A classification under the Article 14 is valid only if it is found on intelligible criteria, such as a differentia as the rational nexus between the objectives sought to be achieved. Rational nexus between the objectives and the discrimination. Article 14, which deals with no discrimination, equality before law and the equal protection of law. But Article 14, the equal protection of law, gives the validity for discrimination in between the classes. In between the classes, the discrimination should be a rational discrimination. Rationality of the discrimination should be based on an intelligible criteria. An intelligible criteria. A marginalized section need a discriminatory treatment, means intelligent criteria, and a nexus between the classification and the objectives sought to achieve. Correct. Arbitrary in the state action is antithetical to the equality and may violate Article 14 even without the formal classification. Okay. Article 14 prohibits all forms of legislative. That is not correct. Not all forms of legislative classifications. Article 14 prohibits only certain forms of legislative classification that was made in irrational grounds. 1 and 2 are correct, two statements. With reference to the personal law and constitutional scrutiny in India, consider the following statements. In the state of Bombay versus Narasappu Mali, Bombay High Court held that the uncodified personal law are not the laws in force under the Article 13 and hence outside the scope of Article 13. Article 13, that is that the legal only the advocates has to answer. The Narsappa Maulik in Bombay Court held that uncodified personal law are not the laws in force under Article uncodified personal law are not the laws in force under Article 13 and hence they are outside the scope. See, if it is not the law in force under the scope of Article 13 means it is outside the scope. That is correct. Sharabano versus Union of India. The practice of instant triple talaq was invalidated for the first time in India. Correct. It was Shabano. Sharabano, all the personal law, codified and uncodified, automatically become fully subject to Article 13 as laws. Second statement is absolutely correct. Sairabano case not deals with all the laws, codified or uncodified, to have the automatic effect under Article 13. That is not correct. So 1 and 2 may be correct. 2 is correct. 1 may be correct. And the third is absolutely not correct. So 1 and 2 are the answers. With reference to the writ jurisdiction in India, the writs can be issued against the private bodies if they are discharging the public functions. Correct. Supreme Court, private bodies if they are discharging the public functions. Correct. The Private Security Act. Supreme Court can issue the writ under Article 32 only for the enforcement of the fundamental rights, whereas the High Court can give the writ. Correct. Even for the legal rights. Correct. Only the Supreme Court has the power to issue the writ for the enforcement. Only the Supreme Court has the power to issue. That is not correct. It is also the High Courts of India and any court if it is conferred by law of the Parliament. 1 and 2. Two statements are correct. Under the protection of the Human Rights Act of 1993, National Human Rights Commission is empowered to issue arrest warrant against the violators. Not correct. Conduct inquiries into alleged human rights violations in India with the summut of cognizance. Correct. Correct. B is correct. With reference to the 27, with reference to the freedom of press and the related judicial interpretations, consider the following statement. Indian Express newspaper versus Union of India case that the Supreme Court held that taxation measures should not be used as an indirect method to curtail the freedom of press. Correct. Shreya Singhal versus Union of India, the Supreme Court struck down section 66A of the IT Act as unconstitutional for the violation of the Article 19 clause 1 subclause A. Correct. Shreya Singhal versus Union of India in section 66A was upheld by applying the doctrine of reading down. Not correct. Doctrine of reading down. Doctrine of reading down is applied by the court in some of the laws made by the Parliament or the state legislature, in which the court read the provisions as it concurred to the constitutional provisions. As it concurred to the constitutional provisions. A law may violate some provisions of the Constitution, but the interpretations of the court that the effects of the law is concurring to the other provisions of the Constitution. That is doctrine of reading down. But court declared both the statement 2 and 3 statement are the contradictory to each other. Statement 2 is right and statement 3 is contradictory. And 1 and 2 are correct. 2 statements are correct. Answer is B. Under the National Commission for Women Act of 1990, National Commission for the Women is not empowered to. National Commission of Women is not empowered to. National Commission of Women investigate, examine all the matters relating to the safeguard of women. Correct. And National Commission of Women issue legally binding directions, not empowered to give the legally binding directions. National Commission of Women is not empowered to give legally binding directions in order to the government, not empowered. B is the answer. Which of the following statement regarding the Finance Commission is not correct from the constitutional perspective? Which of the following statement regarding the Finance Commission is not correct? Finance Commission recommends the distribution of tax revenue between union and state. Correct. Its recommendations are binding on the not correct. Finance Commission recommendations are not binding on the union government. Not correct. B. Question 30. சில authentic statement புடிச்சோம்னா விட்டு போயினா இருக்கலாம். Okay. Consider the following statements. That doesn't mean that you should not read the other statement in your exam. Here we are discussing. That means by going through the particular statements means we will reinforcing the fact. Consider the following statement. Statement 1. The Indian Constitution, the conflict between fundamental rights and directive principles have been addressed to the constitutional amendment and judicial doctrine. Correct. A conflict between part 3 and part 4 to be addressed by the court or by the amendments. Then Article 15 clause 4 was inserted following the Shanmugam Durarajan judgment, and the 9th schedule was introduced to protect the land reforms right. Correct. Golaknath case of 1961 upheld the unlimited parliamentary power. Upheld. That is not correct. It was the Golaknath versus State of Punjab. For the first time, Supreme Court declared, restricted the parliament. Restricted the parliament cannot amend the part 3 provisions of the constitution. Golaknath case is important for Golaknath case is important for the 2 reasons. One is Tonagano. One is Golaknath case is important because Golaknath case established transcendentality of the fundamental rights. Parliament cannot amend any provisions of the part 3 of the constitution. Part 3 enjoys the transcendental position. Any amendment to the part 3 should be of reconstituting another constituent assembly. Reconstituting another constituent assembly. Okay, that is the Golaknath case. So unlimited parliamentary power. Case stated that Article 368 establishes only the procedure to amend, but not the power to amend. And the second one is Golaknath case also pronounced the doctrine of prospective overruling. Prospective overruling. That means a new stand, a reversed stand of the court shall be effective with prospective proceedings. So statement 3 is incorrect. Statement 3 is incorrect. With reference to statement 3 is incorrect. Statement 3 incorrect, na? C. With reference to the mob lynching and the judicial directions, consider the following statement. Bharatiya Nyaya Sanhita. Bharatiya Nyaya Sanhita prescribes the death penalty as the sole punishment for the mob lynching. That is not correct. கொஞ்சம் மாட்டுக்கறி எடுத்துட்டு போ. இது சென்ட்ரல் சைடு அப்படி போனீங்கன்னா, குறிப்பா டெல்லி சைடு போனீங்கன்னா ஒரு 10 பேர் சேர்ந்து சாவடிச்சுவாங்க. மாப் லின்ச்சிங். ஹானர் கில்லிங், மாப் லின்ச்சிங். மாப் பங்களாதேஷ்ல நடக்கிறது மாப் லின்ச்சிங். ஒரு கும்பல் சேர்ந்து சாவடிக்குது. கும்பல் சேர்ந்து ஒருத்தனை சாவடிக்குது. That is mob lynching. பேப்பரை படிக்கிறது இல்லை. நாட்டில் என்ன நடக்குதுன்னு தெரியல. Okay. The Tehseen Poonawalla case focused exclusively on the punitive measures. Focus exclusively on punitive measures. That's wrong. Tehseen Poonawalla case, in which the court has given the directions for the governments to take action for preventive measures, preventive measures and compensatory measures, not only on punitive measures. That is wrong. 2 is wrong. Supreme Court reaffirmed the binding nature of its guidelines, reaffirmed the binding nature of its guidelines while declining to fix uniform compensation. Correct. 1 correct, 3 correct. National Crime Record Bureau has consistently published. No, that's not correct. That's not correct. 1 and 3 are correct. One wrong. Sorry. Second is wrong. It is not exclusive. Second is wrong. Supreme Court, third is right. 3 only right. Answer is C. With reference to the obscenity laws in India, consider the following. Bharatiya Nyaya Sanhita primarily governs the online. Primarily governs the online consider. Okay. Avik Sarkar adopted the community standard test. Obscenity, Avadur. So obscenity in the social media is the criminality of the obscenity is based on community standard test. Community standard test. You say, for example, you take publication of nudity. In nudity, Western standard is different to the Indian standard. Community standard test. That Eklund test, that was of Western standard. That was not of India. 3 is not correct. Navjit Johar subordinated constitutional morality is always supreme to the public morality, to the religious morality in India. So the 4th is not correct. 3 is not correct. 1 and 2 are correct. Bharatiya primarily governs. Primary, that is not correct. 2 only correct. D. With reference to the right to property, consider the following statements. Shankari Prasad case in 1915 held that the constitutional amendment or not law under Article 13. Article 13. So it cannot be declared as invalid. Correct. Article 31B protects 9th schedule. 9th schedule, the law. That means validations from the being challenged in the court. Correct. Keshavananda Bharati case held that the right to property is not a part of basic structure. That is not correct. 3 is not correct. 44th Amendment has made property a legal right under Article 31, a legal right, contract right under Article 300A. Correct. So 3 is not correct. 3 is not correct. Answer is A. With reference to the writ jurisdiction, consider the following statement. NBFCs, non-banking financial companies. NBFCs automatically fall under the Article 12. The non-banking financial company is not a state. Article 12 definition of the state cannot be applied. Non-banking financial companies is a legal citizen. Legal citizens and not a state. Private bodies forming the public duties may be subject to the writ. Correct. High Court may refuse the writ relief in appropriate cases. Correct. Parliament may empower the other court. Correct. 2, 3, 4. Correct. Answer is C. Consider the following statement with reference to the right against self-incriminating evidence under Article 20, Clause 3. Right against self-incriminating evidence under Article 23, Clause 3 deals with certain exemptions for the individual. That exemptions not include fingerprints, compelling the fingerprints. Article 20, Clause 3 states no compulsion can be made by the individual to provide the self-incriminating evidence. Then forced narco analysis violates. Correct. Narco analysis is one in which the application of certain drugs as sodium pentathlline, when applied, When applied, the person would give the answers for the inquiries. Give the answers for the inquiries, what was declared illegal by the court. Legal by the court, called as narco analysis. Forced narco analysis violates Article 20, Clause 3. Correct. Then the Criminal Procedure Act limits the collection of the evidences to convicts only. Not correct. It was not the collection of evidences of all, not only the convicts, but also then the compelling voice samples violates the article. Not voice samples, compelling the voice samples. If anybody sent a threat, is a legal evidence. Voice samples. So 4 is correct. 3 is not correct. 2 is correct, and 1 is correct. 1 is correct. Then the first 2 is correct, and 4 is correct. 4 is correct. Violates, not violates. So 1 and 2 is correct. 1 and 2 is correct. Answer is B. Which one of the following statement regarding the National Commission for the Women is not correct? It can examine, safeguard the woman and safeguard for the woman under Constitution. Correct. It may intervene in the court cases regarding the women's rights. Correct. It has the power to summon the individuals for inquiry. Correct. But it cannot legislate. It cannot initiate the legislations independently. That is not correct. Answer D. Consider the following statement with reference to the halal certifications on the Constitutional Office. All the questions represents in the background of current events. In the background of the current events. Consider the following statements with reference to the halal certification on the constitutional offices. Mandatory halal certification for all products was supported by the Solicitor General of India. Not correct. Solicitor General not supported compulsory halal for all biryanis. Okay. Then Director General of Foreign Trade, DGFT, regulates the halal certification for the meat exports. Correct. Some Gulf countries exports needs halal certification regulated. India lacks a unified national halal certification framework. Correct. A Solicitor General is appointed under the Article 76. There is no constitution not talks about the Solicitor General. It deals only with the Attorney General. No. It deals only with the Attorney General. 4 is not correct. 4 is not correct. The question parungma. Question paper parungma. Consider the following statement with reference to the halal certification. Mandatory halal certification for all product was supported by the Solicitor General of India is not correct. DGFT regulates the halal certification. Correct. India lacks the halal. Correct. 1 and 4 are not correct. 2 and 3 are correct. Answer is B. Consider the following statement about the Indian Constitution. Indian Constitution. The Constitution provides for the extract strength of the Council of Ministers at the center. Not correct. 91st Amendment states that the strength of the Council of Ministers shall not exceed 15% of the total membership. 15% of the presentation in the Lok Sabha. Okay. That is ceiling. The ceiling is correct. Correct. 2 is correct. 39. With reference to the Constitution of India, consider the following statement. Right to property is still recognized as a constitutional right. Yes, a constitutional right under Article 300A of the Constitution, but a contract right. A person cannot be deprived of right to property except with authority of the law. Both are correct. with reference to the Muslim woman right to maintenance and related judicial developments, consider the following. The Muhammad Ahmad Khan versus Shabanu case, Supreme Court held at section 125 of the Criminal Procedure Code, upright irrespective of the religion to any individual who left the wife without any compensation. Correct. The Muslim Woman Protection of Rights on Divorce Act of 1986 confined a husband's liability and to provide maintenance strictly to the idadat period. Correct. Idadat period means 1 to menstrual period. Correct. Then the Daniel Latif versus Union of India case, the Supreme Court struck down 1986 Act. 1986 Act not correct. Not correct. The 21st Law Commission of India recommended immediate. No, it recommended that Uniform Civil Code need the social acceptance. 3 and 4 is not correct. So answer B. With reference to the bonded labor in India, consider the following statement. Article 23 of the Constitution prohibits the forced labor, including bonded labor. Forced labor, including the bonded labor. Any form of the human trafficking. Behar on all forms of human human trafficking. Then adolescents are completely prohibited from the employment under the Indian labor laws. Adolescents are completely prohibited from employment under the Indian labor law. Not correct. Say, for example, in the Kashmir embroidery industries, carpet industries, slate industries. Okay, not correct. Not completely prohibited. Then weak interstate coordination adversely affect the enforcement of the laws against the bonded labor. Correct. Bonded labor arises exclusively from the debt-based arrangements. Correct. 1 and 2 are correct. 1 and 2 exclusively from the debt-based arrangements. The 3 correct. 3 and 4 are correct. 3 and 4 are correct. 1 and 2 are not correct. B. Answer. Okay. Article 23 of the Constitution prohibits the forced labor, including the bonded labor. State shall eliminate the forced labor, including bonded labor. Correct. Correct. 1 correct. Adolescents are completely prohibited. Not correct. Not completely prohibited. Then weak interstate coordination. Correct. Lacks weak coordination. So 1 correct, 3 correct, and the 4 correct. So C as the answer. So negative mark. Which reference to the union budget. You say one thing. Negative marks are mostly not because of our lack of knowledge, but because of lack of application. Negative marks இதுல தான் வரும். புரியுதா? தெரியாதது அட்டெண்ட் பண்ண மாட்டோம். ஓகே, தெரிஞ்சது தப்பா அட்டெண்ட் பண்ணும். அதான் நெகட்டிவ். ஓகே, தேங்க்யூ. With reference to the union budget 2025-26, the maximum loan limit under the Kisan credit card scheme was enhanced to 10 lakhs, 30 lakhs. Dhan Dhanya Krishi Yojana is excellent. It's a pilot scheme for only 100 villages, 100 districts. Maritime Development Fund with allocation of 25,000 crores. Urban Challenge Fund approach. இது எவ்வளோ என் கையில் இருக்க காசு எனக்கு தெரியல. ஓகே, 42nd amendment inserted social secular integrity. Then 44th amendment Article 21 Maneka Gandhi case. Then the 104th amendment. 42nd ensured 2021 cannot be suspended even during 44th amendment. 44th amendment was the result of habeas corpus case. Result of the habeas corpus case. Shukla versus ADM Jabalpur. ஏபிஎஸ் கார்பஸ். அவ இது எமர்ஜென்சில வந்து அரெஸ்ட் பண்ணிட்டாங்க. அரெஸ்ட் பண்ணப்போ அவர் ஏபிஎஸ் கார்பஸ் அப்ளை பண்ணார். உனக்கு ஏபிஎஸ் கார்பஸ்ல ஒன்றும் கிடையாது, உனக்கு உள்ள போகணும். அப்போ இட் பிகேம் a question whether a person arrested under the emergency law is eligible for the writ of remedy of habeas corpus, called as Shukla versus ADGM Jabalpur case, Additional District Magistrate Jabalpur case, in which the court declared that the person is not eligible. Person is not eligible. All Congress person judging, except one, H.R. Khanna, stated that existence of Article 21 gives life to Article 32. Life to the Article 32. Actually, that was acknowledged by 44th Amendment, Janata government, which ensured Article 2021 cannot be suspended and Article 32 Clause 1, habeas corpus, cannot be suspended. Then Article 21, that is due process of law, 4, C4. Article 104, extension of Anglo-Indian nomination. Answer is A. அது அப்புறம் வச்சுக்கலாம், கணக்கு தெரியல. மேக்ஸிமம் லோன் லிமிட் 30 லட்சம். ஸோ அது இல்லை. தன்தானியா கிருஷி யோஜனா 100 டிஸ்ட்ரிக்ட் தான் போட்டிருக்காங்க, அது இல்லை. அர்பன் சேலஞ்ச் ஃபண்டா அது இல்லை. தேர்ட் ஒன்றது தெரியல. ஓகே, ஸோ மூணாவது தான் இருக்கும், தெரியாது தான் இருக்கணும் ஆன்சர். With reference to the Places of Worship Act of 1991, consider the following statement. Shahi Jama Masjid at Sambul is notified as a Religious Worship Monument Act. Religious Worship Monument Act. Not correct. Section 5 of the Monument Protection Act give exemption to the Ram Janmabhoomi Babri Masjid dispute. Correct. Court may examine the religious character of a place of worship or limited purpose, limited circumstances. A court can examine the religious purpose of the place of worship in the broader circumstances. All disputes settled prior to the commencement of the act was abated under Section 4. All disputes settled prior to the commencement of the act is considered as valid. The fourth is correct. 2 is correct. 1 and 3 is not. 1 and 3 are not correct. Answer is B. Consider the following statement. Indian Constitution, following a system of functional overlap over the legislature, executive, judiciary, rather than strict separation of powers, and incorporate a system of balance and checks. There is a functional overlap in which a legislature works as a court. What are the instances in which the legislature works as a court? When Parliament works as a court. Correct. Impeachment of the judges of Supreme Court and the High Courts of India, in which the Parliament functions as the court. So there is always overlapping. There are executive judiciary. Tahsildar is executive judiciary. Commissioner of Police is executive judiciary. Always overlapping. Court can come out with laws. Court direction operates with the validity of the law. That is D.K. Basu guidelines, Nirbhaya guidelines, Visakha guidelines, in which the court codifies and gives its operation as a law. So always overlapping. Correct. Article 122 and Article 212 restricts the judicial scrutiny of the legislative procedures of Parliament and state. That's also correct. Article 122, which establishes Parliament is supreme in its own domain. Court cannot interfere into the Parliament. Court cannot interfere why the Speaker of the Lok Sabha suspended some members. unless it violates the fundamental rights. Jagadambika Pal case. Also correct. Both are correct. Then 46, with reference to the doctrine of separation of powers in India, consider the following statement. Indian Constitution adopt a system of functional overlap and the strict separation, correct? Indira Gandhi versus Rajnarayan case, Supreme Court upheld the absolute legislative supremacy, not correct. Indira Gandhi versus Rajnarayan case by the Supreme Court dealt with the issue of the issue of independence of the election commission, not absolute legislative supremacy. Okay. Legislative supremacy. Then Article 122 and 212 restrict the judicial scrutiny of the legislative procedures within the Article 122 restrict the judicial, correct? The power of the pardon and the ordinance making reflect the system of checks and balance. Presidential power of pardon, that is, president act as a judge, and the presidential power of ordinance makes their reflect the system of checks and balances. Checks and the balance. Power of pardon. Why the president is conferred with the power of pardon is to annul some judicial errors. Why he is possessed with the ordinance? He possessed with the ordinance lawmaking power at the time Parliament is not in session. So it makes the checks and balances, correct? 3 correct, 2 is not correct, and 1 is correct. 1, 3, 4. Answer is B. With reference to the land allotment and the constitutional doctrines, consider the following statement. Arbitrary land allotments by the state may violate Article 14 of the Constitution. Correct. State cannot allot the land of its own. Court have applied the doctrine of colorable legislative excess of power of land allotment. Correct. Doctrine of colorable legislations. That means a law whose intention is different, but declaration is different. A law whose intention is to do something, what you cannot do directly is doing indirectly. A law, suppose a law is to ban, intention is to ban the Communist Party, but stating red color is prohibited. Red color is, that is colorable legislations. The state act is to appropriate the land, but declaring it is land development. That is the colorable legislation. Court applied the doctrine of colorable legislation, excess of power of land allotment case. Public trust doctrine has been invoked to restrict the state discretion over the land. Correct. Discretion of the state in the land allotment matter is absolute, not correct. Discretion of the state in allocation of the lands is subjected to the judicial review. 1, 2, and 3. Answer is C. With reference to the human trafficking laws and the institutions, consider the following statement. Human Trafficking Prevention Act of 1956 mainly addresses the trafficking of sexual exploitation. Mainly addresses as trafficking of the sexual exploitation. Correct. Then UN Trafficking Control Organization defines organized criminal groups, not organized crimes. Defines organized criminal groups, not organized. That is not, both are defined. Then AHTUs, or the operational units, not law drafting bodies. 1 is correct, 2 is correct. OCIA is a statutory body. OCIA is the statutory body under the NIA. OCIA is being 48. With reference to the minority status of Aligarh Muslim University, consider the following. The genesis of an institution is important to determine whether it was established by the minority under Article 30, pronounced by the court. Correct. Minority educational institutions must admit and educate only the minority communities. So not correct. It is a preference only. Then Supreme Court has conclusively declared AMI, Aligarh Muslim University, not as a minority institution. Rejected. Rejected. So 3 is not correct. 2 is not correct. 1 only correct. A. Under the constitutional scheme governing the elections in India, the enforcement of model code of conduct primarily derives legitimacy of which of the following? Model code of conduct, right from 1967, came as a procedures based on the consensus of the political party, but given the legal validity under rule of law. Under the rule of law, enforcement of law. With reference to the Central Information Commission, consider the following. CIC is a statutory body, and the removal of the Central Information Commissioner followed the same procedure as the prescribed for the judge of the Supreme Court. Commission enjoys the power of the civil court, but does not have the power to punish for the contempt. Correct. The Central Information Commission submits the annual report to the President. Correct. The Central Information Commission is a statutory body established by the law. Correct. All are correct. Statement 1. There have been an important development in the recent years relating to the appointment and services conditions of the information commissioners under the Right to Information framework. Correct. Statement 2. Right to Information Amendment Act of 2019 fixes the tenure and service conditions for the Information Commissioner in the Act itself. Not correct. It was to be determined by the government. Then in Anjali Bharadwaj versus Union of India case, Supreme Court directed that the criteria for shortlisting the candidates for the appointment as the Information Commission to be disclosed to the public. Should be disclosed to the public. That is not correct. 1 and 2 are correct. 1 and 2 are the correct. Should be disclosed to the public. Yeah, put 52. 48, 52. Okay. Consider the following statements. In India, the preparation and the revision of the electoral rolls accuse the verification mechanisms that are distinct from the other countries having a comprehensive civil registries. Correct. And intensive revisions involves a fresh enumeration of electorals, unlike the summary revision. Summary revision is nothing but update. Intensive revision is verification. Correct. Unlike the countries with the civil registries, India requires independent verification of voters, independent verification of the voters by the Election Commission. Correct. Special intensive review. All are correct. All are correct and substantiate the statement 1. Then, in a special intensive revision for the electoral roll, 54, the Election Commission adopts the measures to improve the accuracy and integrity of the voter list. Correct. Then the special intensive review enumeration forms and the supporting documents are digitalized to enable the verification and reduce duplication. Correct. During the special intensive review, the representation of the recognized political party, BL, booth level agents, can participate in correct. Both are correct and substantiate the first statement. Consider the following. So, National Commission of Minorities is a statutory institution intended to safeguard the interest of the minority community through an advisory and monitoring role. Correct. National Commission for the Minorities involved in initially a that is correct. Initially, it was simply established by a resolution in the Parliament, then given the legal status. Correct. The recommendation of the National Commission of Minorities are advisory in nature and not legally binding. Correct. All are correct. And substantiate the statement 1. Then 56, with reference to the constitutional safeguard for the minorities, consider the following statements. Constitution of India does not define the term minority. Correct. Jains were notified as a minority community at the national level in 2014, correct? National Commission for the Minorities is the sole authority in enforcing. That is not correct. National Commission for the Minorities is a statutory body that reports to the central government. That reports to the President of India. The first statement is correct. Second statement is correct. Answer is C. With reference to the powers and the functions of the governor, consider the following statement. Governor's power to summon the assembly is absolute discretion, not correct. Governor's power to summon the state legislative assembly based on the advice of the state council of ministers. Then Punchi Commission recommended the removal of the governor as a chancellor. Recommended removing governor as a chancellor of state universities, not correct. Punchi Commission not recommended that. The Supreme Court of India, Supreme Court fixed a strict 6 months deadline for the assent of the bill. Court itself removed. Governor, there is no a fixed period of the 6 month deadline for the governor. Is not an obligation of the governor to give assent. An unreasonable delay by the governor on the bill can attract the judicial review. Correct. 4 is correct. 2 is correct. And 1 is not correct. 2 and 4 is correct. Huh? 2 not correct. 1 is governor not correct. 2 is not correct. And 3 is not correct. And 4 is correct. Only one statement. Which of the following commission recommended that the removal of the governor should ordinarily involve the consultation with the Chief Minister of the state? Sarkaria Commission. It was the Sarkaria Commission recommended appointment of the governor only with the consultation and also the removal. Then statement 1, Legal Services Authority Act. Legal Services Authority Act of 1987 provides a statutory framework to ensure access to justice and the free legal aid, thereby strengthening the constitutional mandate for equal justice, as given by Article 39A. The Act gives a statutory effect to Article 39A and provides a legal statutory recognition for the Lok Adalat, that is the People's Court. Both the statements are correct. State Legal Services Authority is headed by the governor, and the members of the SCST is entitled to legal aid only if they satisfy the not satisfy with the legal aid income limits. 1 and 2 are correct. 1 and 2 are the 1 and 2 say not satisfied by the income limits. 1 and 2 are correct. First statement 1 and 2 are the correct. Okay, 3 is not correct. C, correct. Consider the following statement. Legal aid mechanisms in India often face the issues of effectiveness and public trust. Correct. The system largely relies on generalist lawyers with the limited incentives and institutional support. So they are not they hesitate to provide the service. Both are correct. And substantiate each other. Consider the following statement. Legal aid delivery in India often suffers the uneven quality and limited public confidence. Correct. Then statement 2. This is partly due to the independence on the panel lawyer with a limited incentives and the same question is repeating. Okay, both are correct. Answer A. 62. With reference to the constitutional morality, consider the following statement. Constitutional morality, that means all the acts, legislations, and functions according to the principles of the Constitution, values of the Constitution. Dr. Ambedkar said the constitutional morality is natural to the citizens, to the Indian society. If the society of India traditionalized with the moral rights of the Constitution, means there is no need of Constitution. Dr. Ambedkar never said like that. Then George Grote linked it to the respect for the constitutional forms and freedom to criticize authority. Correct. Constitutional morality means it's a respect to be maintained for the constitutional forms and the freedom to criticize authority. Correct. Supreme Court has applied constitutional morality against the discriminatory social customs. Correct. Constitutional morality requires the judges to follow only the literal text. Not correct. Judges can function by their own conscience, concurring to the values of the Constitution. 2 and 3 are correct. Answer is B. With reference to the challenges to the constitutional morality, consider the following statement. Constitutional morality supports viewing the Constitution as a living document. Correct. Judicial activism alone is the sole threat to the Constitution. Not correct. Judicial activism alone is not, it is not correct. Judicial activism is the role of judiciary in the domains of the executive and legislation, is not a threat to the constitutional morality. Concurring to the constitutional morality. A. Answer is A. With reference to the center-state fiscal relations, consider the following statement. Ending GST compensation has hit the manufacturing state more. Correct. Vertical fiscal imbalance is due to mismatch between revenue powers and the expenditure duties. Correct. So the revenue powers, union has got the revenues, but the state has responsibilities. That is the fiscal imbalance. Then cesses and surcharges are the part of divisible pool. It is not a device. It is not divided between union and state. Cess is a levy for a particular objective. It is appropriated by the union. And surcharges are to meet the revenues of the collections, appropriated by the union, not device. And then integrated GST, interstate GST is shared between union and the state immediately. So it is the 1, 2, 1, 2, and 4 are 1, 2, and 4 are correct. Answer is C. With reference to the political development in the Ladakh, consider the following statement. Lay Apex body on the Kargil Democratic Alliance merged to form a political party. Those are both are movements. Wangchuk, that environmental activist recently arrested. Both are movement. Job reservation, recognition of the local languages are the part of negotiation with the union government. Correct. Violence erupted following the rejection of the 6th schedule demand. Not correct. The union government not rejected the 6th schedule demand, but in negotiation. Civil society organization publicly claimed responsibility for the violence. They never claimed the responsibility for the violence. So, so 1 incorrect, 3 incorrect, 4 incorrect, 2 only. Ladakh, second statement 1. Ladakh witnessed the renewed unrest despite earlier agreement and dialogue between the union government. Correct. Divergent perceptions and the expectations between the union and the local protest group contributed to the escalation of the tensions. Both are correct. Substantiate A. Then 67. With reference to the proposals of the simultaneous elections, consider the following statement. Simultaneous single-stage synchronized elections was proposed. Correct. Article 82A empowers the Election Commission to alter the tenure of the State Assembly. Empowers the Election Commission to alter the tenure of the State Assembly. That is not correct. The laws of the Union Territories seeks to align the assembly terms with that of the Lok Sabha. It no need of the it is natural and no need of separate laws. Newly elected laws of the Union Territory seek to align the assembly terms with that of the Lok Sabha. A newly elected legislature may serve only the remainder of the synchronized term. If a state legislature was dissolved, it need not to serve as a reminder. The first one is correct. First statement is correct. Second statement is not correct, and the third is correct. Yeah. Then the 68, the Committee of Simultaneous Election recommended that after a premature dissolution, the newly elected house should generally given a full term. Generally a full term. That is not correct. After a premature dissolution, A new of the elected house may continue, but not given a full term. A recommendation was intended to prevent the re-emergence of staggered elections. Staggered, that is correct. Statement 1 is incorrect. Okay. 67th. A newly elected legislature may serve only as a reminder. A legislature would continue for the reminder terms, but not the new 5-year terms. Okay. Up to the extent of Lok Sabha elections. Lok Sabha, இப்போ ஸ்டேட் லெஜிஸ்லேட்டிவ் அசம்பிளி டிசால்வ் பண்ணிட்டா ஒரு வருஷம் இருந்ததுன்னா லோக்சபா இருக்கிற வரைக்கும் அப்படியே கண்டினியூ பண்ணிட்டு முடிச்சிடணும். அவ்வளோ. நியூலி எலெக்டட் லெஜிஸ்லேச்சர் may serve only a reminder. கரெக்ட் தான். One three optional இல்லையா? Single stage first correct. Okay, second illa. Okay, laws for the union territory seeks to align the assembly term with the correct. Okay, the newly elected legislature may serve only the remainder of the synchronized terms. இப்போ அமலுக்கு வந்ததுன்னா லோக்சபா பீரியட் 2 வருஷம் தான் இருக்கு, சைமல்டேனியஸ் எலெக்ஷன் வந்ததுன்னா கரெக்ட் தான், ஆப்ஷன் இல்ல. ஓகே, ஃபைன். 69. With reference to the president rule, consider the following statement. Article 19 is not automatically suspended during the operation of the president rule. It requires the special order of the president. Okay, correct. Extension of the president rule beyond 1 year requires the national emergency and the certification of the election commission. Extension of the president rule beyond 1 year requires national emergency and the certification of the election commission. Extension of the president rule beyond 1 year. ஒரு வருஷத்துக்கு மேல போச்சுன்னா எலெக்ஷன் கமிஷனுடைய சர்டிபிகேஷன், அங்க எலெக்ஷன் நடக்க முடியாது. ஓகே, laws made by the president rule lapse automatically after revocation. Not correct. Parliamentary approval for the president rule requires a special measure, not a simple majority. Simple majority is not correct. 3 and 4 is not correct. 3 and 4 is not correct. 1 is correct, 2 is correct. Answer A. With reference to the Niti Aayog, consider the following statements. Consider the following statement. It was tasked with preparing a national investment charter. Correct. States unanimously supported the Operation Sindoor. Okay, correct. They promote competitive federalism through the performance indicators. Correct. It not allocates the fund directly to the state. 1, 2, and 3. 1, 2, and 3. Statement 1. Cooperative federalism in India requires coordination between the union and the state, but the policy-linked funding conditions can sometimes create center-state friction. Correct. Linking release of certain grants funds to the compliance with the policy framework of union, such as the national education policy, has been the point of center-state debate. Correct. Tamil Nadu. Correct. Both are correct. With reference to the methodology of the recent state performance ranking, economic and fiscal pillars received highest weightage. Correct. Infrastructure assessment excluded from the social indicator. Not correct. Governance was assigned relatively lower weightage. Governance was assigned relatively lower weightage due to measurement challenges. Then the fiscal pillar excluded indicators related to expenditure. That is not correct. Fiscal means expenditure also. Not correct. So first statement correct. Second statement not correct. Third statement correct. 1 and 3. A. With reference to the recent multidimensional state ranking study, consider the following statement. The question on governance. Punjab secured the top position in the infrastructure pillar driven by the indicators such as power availability on the railway. Punjab, Haryana were in the top. Then Kerala as the top in the social pillars. Two, both are correct. Both are correct. With reference to the Waqf Amendment Act of 2025, consider the following statement. Section 40 was deleted, ending the Waqf's unilateral power to declare the property as the Waqf property. Correct. Orders of the Waqf tribunal can be applied before the High Court. Before that, it was not. Correct. Act codified. Act removed the Waqf by user. Act removed the Waqf by user. ஒரு இடத்துல வேலி போட்டு அங்க போய் இந்த தொழுகு பண்ணின்னு இருக்கும். தொழுகு பண்ணின்னு 20 வருஷமா தொழுகு. அதனால அந்த இடம்லாம் வக்ஃப் இடம். That is by user. By user. அந்த இடம் கோயில் நிலமா இருந்தாலும் அது வக்ஃப் இடம். That is by user. அதை எடுத்துட்டாங்க. Okay. Act excluded Limitation Act of 1963 from the not that. So first statement is right. Second statement is right. Third statement is wrong. Fourth statement is wrong. With reference to the reforms relating to the Waqf Board, the Muslim created trust under the Indian Trust Act as generally kept outside the Waqfs. Correct. Act mandates the inclusion of the non-Muslim members in the Waqf boards. Correct. The government on the Waqf land dispute is decided by the senior revenue officers. Senior government versus Waqf land to be decided by the court. The mandatory annual contribution to the Waqf board has been increased. Mandatory annual contribution to the Waqf board, adala act varla. Okay. Fourth is not correct. Government and the Waqf board பிரச்சனை வந்தா collector decide பண்ணும். Senior revenue officer, collector. Senior revenue officer, the collector எடுத்துக்கலாம். Okay. 1, 2 and 3 are correct. With reference to the decentralization and the local governance in India, consider the following statement. Local bodies face the functions fund mismatch. Correct. Sewage management is outside the 11th schedule, shifting accountability to the district. Not correct. Sewage management is a local body powers. Then panchayats are constitutionally barred from open market borrowings. They're not correct. They can borrow from the open market borrowings. 2 and 3 are not correct. Then central sector scheme funds supporting the panchayats, but supports the panchayats, reducing the fiscal flexibility. Fourth is correct. Support the panchayats. 1 and 4 is correct. Answer A. With reference to the unfinished agenda of the decentralization in India, consider the following statement. Decentralization, that is local bodies. Despite conformity laws, State Finance Commission and the state level fiscal and administrative centralization continues in India. Correct. Reclassifying peri-urban areas into the urban local bodies, peri-urban areas. That means a faster urbanizing areas. Newly faster urbanizing is suggested as an immediate governance fix. Correct. Both are correct. With reference to the Article 200 that deals with governor of the Constitution, withholding of the assent by the governor obligates the return of the bill to the legislature. Governor is not obliged to return a bill by withholding assent for a long time. That is not correct. Identification of repugnancy with the central law removes the obligation to return the bill. Correct. If any law of the state legislature contradicts the central law, governor can withhold the bill and cannot need not to return the bill. That's correct. A reservation of the bill for the president is permissible even after the repassage by the state legislature. Correct. Withholding of the assents permanently terminates the bill is not correct. Withholding the assent by the governor not amounted to the termination of the bill. So 2 and 3 are correct, 1 and 4 are incorrect. With reference to the unfinished agenda of decentralization, consider the following statements. Despite constitutional provisions for decentralizing, concentration of administrative and the fiscal power at the state level continues to limit the effectiveness of the self-governance, correct, in India. The State Finance Commission has ensured adequate and predictable fiscal transfer to the local bodies uniformly, not uniformly across the states. Reclassification of the peri-urban areas into the urban area has been suggested as an immediate governance, correct. 1 and 3 are correct. Answer is A. With reference to the international electoral practice, consider the following statement. Countries like Pakistan and Bangladesh permits the candidates to contest the elections as like in India in multiple constituencies, correct. Allowing the candidates to contest from the multiple constituencies may undermine the voter choice by causing the post-election vacancies and requires the fresh elections, also correct. 81. Which of the following statement regarding the arrest of the chief minister is not correct? Arvind Kejriwal. Not correct. A chief minister may be arrested under the law if the credible allegation of the criminal offences exists. Okay. The arrest must be compiled with the constitutional safeguards and due process of law. Correct. Such an arrest may arise the constitutional concern regarding the federalism and separation of power. Correct. If the arrest does not require the legal authorization should be required, may be carried out. It cannot be carried out solely by the discretion of the law enforcement order. The arrest should require the legal authorization of the governor. Then arrest should require the authorization of the courts. D is not correct. Answer is D. With reference to the bill reserved by the governor, with reference to a bill reserved by the governor for the consideration of the president, consider the following statements. Such a bill does not require the legal force until the president grants assent. Correct. The constitution prescribes a mandatory time limit of 6 months. 6 months for the president. No, 6 months for the president. There is no mandatory time limit for the president to give the assent to decide on such bill. The president can utilize pocket veto. So 2 is not correct. 1 only correct. Answer is A. With reference to the Tamil Nadu governor's case, consider the following statements. Reserving a bill for the consideration of the president after it has been repassed by the state legislative assembly violates article. Reserving a bill for the consideration of the president after it has been repassed by the state legislative assembly not violates the article 200 of the constitution. The alleged conflict with the UGC regulation justified by bypassing the state legislation. Correct. Correct. 2 is correct. Yes. As per the court direction, it violates. Correct. Sorry. Both are correct. With reference to the article 371 exemptions, special provisions for the northeastern states, 371 to 371J of the Constitution, consider the following statement. All the provisions under this article contain the explicit sunset clauses. All the provisions of this article, sunset clauses. Sunset clauses means permanent clauses. The law would exist after the day. But that is not correct. That is not correct. Article the special provisions is subjected to change. It is not sunset clauses. Then parliamentary law relating to the land and customary laws apply only to the state concerned. Parliamentary law relating to land and customs apply only to the state, only with the consent of the state. If the state comes under the article 371A, 371G, Mizoram, Nagaland, it need consent of the state. Correct. Article 371D and 371J aim to address the regional imbalance within the state. Correct. The special responsibilities conferred on the governors of these articles are revocable, not correct. Governor's special powers can be changed. So 2 and 3 are correct. Clean state doctrine. Clean state doctrine under insolvency and bankruptcy code. Clean state, that means no liability to the new owner. Any firm which was subjected to insolvency and it was taken over by the new owner, was given without liability to repay for the stakeholders, shareholders and others. That is, new owner is free from the past liabilities. Then with reference to the special constitutional provisions for certain states, consider the following statement. Special constitutional provisions. Absence of periodic review has contributed to the administrative and the legal asymmetry. Correct. There is no periodic review. Such provisions invariably resulted in superior economic, socio-economic outcome. Not correct. 87. Answer A. Cooperative federalism in India. Cooperative federalism in India primarily emphasizes strong central control over the state policies. Not correct. Competition among the states for the central resources. Not correct. Cooperation between union and the state through constitutional and the non-constitutional institutions called as cooperative federalism. C is correct. With reference to the directive principles of the state policy, consider the following statement. DPSP is used by the court to interpret the scope and content of the fundamental rights. Correct. DPSP cannot override the fundamental rights. DPSP cannot override the fundamental rights. Statement 1 is correct. Which of the following is a prominent example of the cooperative federalism? Unilateral imposition of the emergency powers is not a cooperation in the federal relations. GST councils are equally represented by the union and all the states. GST councils. It is GST councils. B. Which constitutional provision supports the right to clean and healthy environment? Right to clean and healthy environment. Article 19, Article 21. Inferred rights. They are called as the inferred rights. Right to clean drinking water, right to clean environment, right to the wages, right to privacy. These are all called as the inferred rights. Inferred rights. Yugikapatta Urimegal under Article 21 of the Constitution. Those rights enjoys the status of fundamental rights, but not the part of Part 3. Which of the following pairs of the DPSP articles? Article 39. Article 39. Equitable. Article 39. Article 39, Clause 2 and Clause 3 called as Economic Charter of the Indian Constitution. Deals with the equal distribution of resources. Distributive justice. Article 39. Then Article 44, the Uniform Civil Code. Article 46, welfare of SC/STs. 39A, free legal. All are matched. With reference to center-state relations, consider the following statement. The 7th schedule demarcates the legislative procedures between distribution of legislative powers. 7th schedule deals with the distribution of legislative powers, financial powers, legislative powers, administrative powers, and the financial powers between union and state. Okay. A state law and a concurrent list is subject to prevail if it is received, if it has received the presidential assent. Correct. A state can legislate any provisions in the concurrent list only with the assent of the President of India. The scope of Article 356 has been judicially restricted by SR Bommai case. All the 3 are correct. Fourth, interstate council as binding, negative marks. Interstate council as not binding. No, don't have the binding powers. Don't have the binding. The recommendations of the interstate council. Interstate council is the extra constitutional or non-statutory bodies, not binding. 1, 2, and 3 are correct. Consider the following statement. Basic structure doctrine limits the parliamentary power to amend the constitution. Correct. Basic structure doctrine ensures that the futures of such federalism, secularism, judicial review, and democracy cannot be abrogated even by the constitutional amendment. Correct. Both are correct and substantiating each other. Then consider the following. The discretionary power of the governor has emerged as the significant source of the center-state frictions in recent years. Correct. The application of discretionary powers has become a friction in the center-state relations in Tamil Nadu, Kerala in the recent years. Recent years, right from that. Because discretionary powers are constitutionally valid. By that, governor is more powerful than President of India. Who is powerful? Who is powerful? President or governor? Governor. Article 164, clause 5, which states governor is more powerful than the president because of application of discretionary powers. Constitutional Article 164, clause 4 states discretionary powers to the governor, but no constitutional provisions gives discretionary power to the president. So, office of governor is more authority, less dignity. Office of president is more dignity, but not authority. Article 164, clause 4, which states, in case of dispute whether a particular power is under the discretion of the governor is not means, governor's decision is final. Governor's decision is final. No such provisions are there for the president. So his office is only for dignity, but governor's office is only for authority. Only for the authority. Problem arises because sometimes governors forget what is their authority and what is their dignity. Okay. Say the question is 94. Constitution requires the governor to act independently of the council. Not. Constitution states there shall be the governor with the head of the state who shall execute his power only in accordance to the aid and advice of the council of ministers of the state. Not correct. So statement 2 is not correct. Statement 1 is correct. Judicial review 95. Judicial review strengthen the constitutional supremacy of India. Correct. Why we need judicial review? We need judicial review to reinforce the supremacy of the constitution. What is judicial review? What is judicial review? Authority of the court to declare the constitutional validity of a law. That is the judicial review. Judicial review empowers the court to examine the constitutional validity of the legislative and executive actions. Correct. Judicial review comes under the domain of Article 13, Clause 2 and Clause 3 of the Constitution. Statement 1 and 2 are substantiative to each other. Then 96. Finance Commission plays a critical role in strengthening the fiscal federalism between the union and the state. Correct. It determines the distribution of the legislative powers between the union and the state. Correct. That's why a critical role. Correct. Both of them correct. It determines the distribution of legislative, negative marks, legislative power, financial powers, not the legislative powers. Statement 2 is correct. So the lesson is negative marks occurs because of our negative application, not of our negativity in knowledge. Okay. Because 96th question means I have to rush. I tend to rush. Okay. Then consider the following statement. In India, the right to have a clean and healthy environment is protected as a part of the right to life and liberty. Correct. The Indian courts have interpreted Article 21 to include the right to have the clean air and the safe drinking water. Correct. Directive principles of the state policy, especially Article 48A, support the environmental protection, have been used by the court to strengthen the environmental jurisdiction. All are correct. And they substantiate the first statement. 98. Functioning of the GST Council reflects the cooperative federalism in India. Correct. GST Council is a constitutional body under Article 279 of the Constitution that provides a platform for the union and state to jointly decide GST-related matters. Correct. The decision of the GST Council was based on the consensus building and sharing participation of the union and the state. All are correct. Substantial. Match the following. Article 21 deals with Article 32, 44, 48A. Answering now. A.